Thank you. Please be seated. All right, the court calls for trial, cause number TG-2023-0002, State of Texas versus Sherry Dunn. Is the state present and ready to proceed?
Yes, Your Honor. May we make appearances?
You may. Would you please do that for the record?
Good afternoon, Your Honor. My name is Peter Jones, appearing on behalf of the state. I'm joined by my co-counsel.
Good afternoon, Your Honor. Edward Gogion, also appearing on behalf of the state.
After the defense has made their appearances, we have a few housekeeping matters we'd like to take up.
All right, thank you very much. And for the defense?
Good afternoon, Your Honor. My name is Willie Sizemore, and I'm here representing Sherry Dunn, along with my co-counsel, Tessa Sizemore, and I have some written entries of appearance, if Your Honor would like a copy.
Yes, please. Thank you. You may approach.
Thank you, Your Honor. And may I approach the jury with copies of written entries of appearance as well?
That won't be necessary, but thank you for asking.
Yes, Your Honor.
All right, and is the defense ready to proceed?
Yes, Your Honor.
I understand there are some housekeeping matters constructively outside the presence of the jury. Let's proceed with those.
Yes, Your Honor. May we have permission to move freely about the well of the courtroom during opening statements, examinations, and closing arguments?
You may.
Once an exhibit is admitted into evidence, should we ask Your Honor's permission before publishing it on screen for the jury, or may we have standing permission to publish admitted exhibits?
You have standing permission to publish those that have been admitted.
Yes, Your Honor. Next, the parties met and conferred before trial and agreed to pre-admit a series of exhibits. I'd like to put those on the record now.
You may.
The exhibits are Exhibit 37.
Now, are these numbered not state exhibits and defense, but consecutive exhibits?
That's correct, Your
All
Honor.
right, thank you. 37.
38 through 49. 52 through 59. 63 through 66. 93 through 100. And 102.
All right, and does the defense stipulate that those are the agreed pre-admitted exhibits for the trial?
Yes, Your Honor, that is correct.
All right, those are as numbered, admitted at this time.
Your Honor, the state also came with 2 motions in limine, but we met and conferred with opposing counsel and reached substantive stipulations on those as well.
Very good, thank you. You may proceed with that.
The parties agreed to exclude a 2012 felony conviction of Matthew Collings, as it's outside the 10-year window in Rule 609.
All right, thank you. Okay.
Next, the parties agreed to exclude the underlying details of a 2016 felony conviction of Matthew Collings. We understand the state can elicit testimony that he does in fact have that conviction, but those underlying details about what happened, those are excluded.
And that's a separate conviction than the one you just mentioned?
Yes, Your Honor.
What's the year on that conviction?
2016.
Thank you. All right, any others from the state?
No, Your Honor.
All right, any other pretrial matters from the state at this time?
No, Your Honor.
Does the defense have any housekeeping matters we need to take up before we bring the jury in?
Yes, Your Honor. As our understanding is, the technology here today does not allow us to differentiate from screens in the courtroom today. If it was to become a necessity that we needed to impeach a witness, may we assume or constructively assume that the testimony that we're impeaching with is not on the large screen, but only for the witness to view on the smaller screen?
Yes, we will proceed constructively on that matter.
Yes, Your Honor. And we also brought forward one motion in limine today that was stipulated to by the prosecution, and that motion addressed a prior conduct of Mr. Matthew Collings in this case, who will be the man who Sherry Dunn had an affair with, Your Honor. And this prior instance is when Sherry Dunn had bruises left on her arms by Matthew Collings, and that has been determined by stipulation to be admissible by both parties today.
All right, and that is accurately stipulated?
Yes, Your Honor.
All right, that is granted.
Yes, Your Honor, and the defense is ready to proceed whenever the state is.
All right, so We're going to bring the jury in. The defendant will have constructively been arraigned and pled not guilty. And when the jury is seated, we will proceed with opening statement. So at this time, the jury is being brought in. I'll ask formally and before the jury, is the state ready to proceed?
Yes, Your Honor.
Is the defense ready?
Yes, Your Honor.
Does the state wish to make an opening statement?
We do.
You may proceed, counsel.
She wasn't a victim. She was in on it. It's 2 o'clock in the morning. The defendant, Sherry Dunn, is lying in bed, wide awake. Suddenly, her bedroom door swings open, and there's an intruder standing in her doorway. The defendant doesn't scream, doesn't wake her husband, doesn't reach to dial 911. Instead, she smiles. She's not afraid of the man. She's been waiting for him. Members of the jury, the evidence will show that that man was the defendant's boyfriend. You'll learn they'd been having an affair for months. The evidence will show the defendant wanted to leave her husband, but she wanted his trust fund money first. So she made a plan. Fake her own kidnapping. Her boyfriend would break in, enter the home, tie up her husband, grab her, and demand a ransom. $500,000, or he'd never see his wife alive again. Problem is, you'll learn her husband didn't pay. So the defendant came home, told everyone she'd been kidnapped. The evidence, the physical evidence, and the defendant's own text messages, they'll show you that that's not true. That the defendant was never kidnapped. She wasn't a victim. She was in on it. The state has charged the defendant with 2 crimes: aggravated kidnapping and attempted theft. Now, attempted theft is what it sounds like. The defendant trying to take her husband's money. Aggravated kidnapping might sound a little more unusual because the defendant's husband never left her home. But as the judge will tell you, when a person is physically confined because they're drugged or threatened or bound, well, that's kidnapping too. Matthew Collins will take the stand. He's going to help the state meet our burden today. Now, I want to be upfront with you about what that is. As the state, we have to prove every element of our case beyond a reasonable doubt. But you'll learn that most of what we have to prove is undisputed. We expect it will be undisputed that the defendant's husband was drugged. Undisputed that he was physically restrained. Undisputed that he was told he had to come up with $500,000 or his wife would be killed. The only thing left for the state to prove is that the defendant was in on it. I told you we'd be calling Matthew Collins. He's already admitted he was the defendant's accomplice. he'll explain in detail how he and the defendant committed this crime. I want to be upfront about who Matthew Collings is. He's a convicted felon, an admitted kidnapper. He's here today as part of a plea deal. His cooperation in exchange for a reduced sentence. If you're wondering how you can just take Mr. Collings at his word, the evidence will show you won't have to. Mr. Collings' testimony will be corroborated by 3 pieces of evidence that show the defendant was part of this. The defendant lied about being kidnapped. The defendant lied about her relationship with the other kidnapper. And the defendant lied about her role in the kidnapping. I'd like to walk through those one at a time to show you how the state will meet its burden today. Starting with that first fact I told you we'd prove. The defendant lied about being kidnapped. Detective Gilpin will take the stand today, and he'll tell you about his interview with the defendant. We'll ask you to compare what the defendant said to the detective with what the evidence says. The defendant said she was taken from her bed at 3 a.m., middle of the night. We'll show you what she was wearing when she got home 2 days later. You'll see, not pajamas. She had sneakers on her feet, sunglasses on her face, a baseball cap on her head. The defendant said she was drugged, that Mr. Collings drugged her on May 10th, on May 11th, on May 12th. We'll show you her blood work from less than 24 hours after she claimed she was released. You'll see. None of those drugs were in her blood. The second fact will prove. The defendant lied about her relationship with Matthew Collings. You'll learn the defendant told the police, "I don't know who Matthew Collings is." Folks, we're going to show you her text messages. You'll learn she had been having an affair with Matthew Collings for 6 months. The third fact will prove. The defendant lied about her role in this kidnapping. You'll see that when the defendant told the detective what happened, she didn't say, "I was forced to participate in this crime." Didn't say, "I was under duress, I was threatened." Instead, you'll learn she said she was a victim. But the evidence will show that when Mr. Collings got to the home that night, he didn't have to break a window, didn't have to pick a lock, didn't have to break in at all. Instead, you'll learn he went to the back door and walked in. The evidence will show that's because he knew that back door would be unlocked. The evidence will show the defendant promised to leave it unlocked. Members of the jury, let me be clear. No one is excusing Matthew Collings for the part he played in this crime. He threatened Mr. Dunn, drugged Mr. Dunn, tried to extort Mr. Dunn. He's going to answer for what he did. But the evidence will show he didn't do it alone. At the end of this trial, we'll ask you to find the defendant guilty of aggravated kidnapping and attempted theft. Because she wasn't the victim. She was in on it. Thank you for your time. Thank you, Your Honor.
Thank you. Does the defense wish to make an opening statement at this time?
Yes, Your Honor.
You may proceed.
Horror, shock, fear. We agree with the prosecution, members of the jury. That was present on May 10th, 2023. But that horror, that shock, that fear was not only felt by Aaron Dunn. It was also felt by my client, Sherry Dunn. And to fully understand why Sherry Dunn felt horror, felt shock, felt fear, you have to go back 1 month before this kidnapping scheme occurred. You see, Sherry Dunn went to a local bar here in Waco called Scruffy's, and she met a man she had been having an affair with. That man's name was Matthew Collins. And they had met there several times before, members of the jury. But what you will learn is that a month before the kidnapping, when they met at Scruff's, this was not a normal meeting for them. Something was different. And it was not different with Sherry Dunn. It was different with Matthew Collins. And today you will learn that Matthew Collins was a construction worker here in Waco, Texas, but he had some difficult things in his life. You see, he had some gambling debts that he could not pay. And he had asked Sherry Dunn to help him pay those debts, but she said no. And what you'll find is that Matthew Collins created a plan to get rid of those debts. And he needed Sherry Dunn to play a part of an unwilling pawn. So on that night at Scruff's, when things were different, you'll learn it was the first time that the defendant threatened Sherry Dunn about this scheme. In Scruffy's that night, Matthew Collins told Sherry Dunn that if she did not participate in this kidnapping, he was going to kill her. And what the evidence will show today is that Sherry Dunn believed him because of what Matthew Collins had done in the past in their relationship. Today, you will hear about an incident that happened in February of 2023. You'll hear that there were bruises left on Sherry Dunn's arms. And those bruises were left by Matthew Collins, one of the star witnesses of the prosecution's case today. And what you will learn is that that threat in Scruffy's in early April was not the only threat that Matthew Collins made. He continued to make threats to Sherry Dunn in her presence at a motel. But this time, members of the jury, he didn't just use his words. He used this gun. You will learn that he brought his gun to her in that hotel room. He showed it to her. He wrapped his hand around it, and he described how he was going to get Aaron Dunn's money, the $500,000, by staging a kidnapping and using Sherry Dunn as an unwilling pawn in Matthew Collins' scheme. But did the threats end in that hotel room that night? Members of the jury, you'll know by the end of today's trial that they did not. They continued until May 10th, 2023. And what Sherry Dunn will tell you on the stand today is that she felt trapped by these threats. She felt like she had nowhere to go, and she feared for her life and her husband's life, so she had to go along with Mr. Matthew Collins' scheme. And that's why you will learn that she unlocked those doors at her house, she turned off those security cameras, and she helped Mr. Matthew Collins with his plan. But did this duress, this fear, these threats end in that house, the Dunn house on May 10th, 2023? No, members of the jury. Those threats continued in Matthew Collings' apartment after the kidnapping had already took place. Sherry Dunn and Matthew Collings were in that apartment alone, and you will learn the threats became more severe and more frequent and more continuous. The gun was in the apartment, and Mr. Collings was in the apartment, and Sherry was still the pawn. He threatened to even cut off one of her toes and mail it to her husband in order to get him to pay $500,000. And those threats didn't stop until Sherry Dunn found a way to escape. Mr. Matthew Collings left to buy cigarettes, and she ran from that apartment across this city to her own home again. And what you'll learn, members of the jury, is when she arrived home and she began to speak to her husband, she made some mistakes. She lied to Aaron and she lied to the police, but Sherry Dunn's going to take the stand today and she's going to explain that. She's going to tell you that she was still in fear because Matthew Collings was still loose here in Mako, and she did not know where he was at with that gun, and she knew that he would act on those threats. She does not have to take the stand today, but she will. And at the end of today's trial, I will come before you and I will remind you of the state's burden, and I will explain to you how they have not met it because Sherry Dunn had horror, shock, and fear from the moment that she stepped foot in Scruffy's that night. Thank you.
All right, State, you may call your first witness.
Yes, Your Honor. The state calls Matthew Collings.
Matthew Collings. Sir, would you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated. You may proceed, counsel.
Yes, Your Honor. Please state your name for the record.
Matthew Collings.
Are you familiar with the victim in this case, Aaron Dunn?
Yes, I am.
How?
That is my ex-girlfriend's husband.
When's the last time you saw him?
It would have been May 10th of 2023
Where did you see him on May 10th?
at his house.
What were you doing?
I was at his house because his wife had a plan to fake a kidnapping.
You said his wife. Who is his wife?
Sherry Dunn.
Do you see Mrs. Dunn in the courtroom here today?
Yes, I do.
Could you identify her by an article of clothing?
Yes, she's wearing a black shirt.
Your Honor, may the record reflect the witness has identified the defendant?
The record shall so reflect.
Before we go any further, I want to talk about why you're willing to admit your role in this crime. Matthew Collings, are you here as part of a plea deal?
Yes, I am.
Originally, what were you charged with in this case?
I believe it was attempted kidnapping or aggravated kidnapping and attempted theft.
What's your understanding of the sort of sentence that those crimes carry?
I think it was 2 years to 20 years.
What have you agreed to plea to?
I pled to a misdemeanor. I think it was unlawful restraint.
What's your understanding of the sort of jail time that carries?
180 days in jail.
In exchange for a reduced sentence and reduced charges, what's your understanding of your obligation under the plea agreement?
That I have to testify to the truth today.
What's your understanding of what happens if you don't tell the truth today?
I think the plea agreement goes away.
Let's start from the beginning. How did you meet the defendant?
I met her back in November at a bar here in Waco,
Which bar?
Scruffy Murphy's.
What happened?
That night, sent her over a drink and we started chatting.
Did you continue to chat after that night?
Yes, we did.
What sort of relationship did you end up having with the defendant?
It started out as a sexual relationship, but over time, I think there were more feelings involved than just that.
Mr. Collins, do you have any proof you were in a sexual relationship with the defendant?
I mean, there's text messages that we have.
Your Honor, permission to display Exhibit 39. It's already in evidence.
You may.
Can you see that on your screen, Mr. Collins?
Yes, sir.
Now, whose messages are in green?
I believe that's Sherry Dunn's.
Could you read the defendant's text messages in Exhibit 39?
All of them?
Yes, sir.
Okay. Had so much fun last night. You want me to read mine too?
Just the defendant's
defendant's?
messages, please.
He's going to see his family for Thanksgiving next week. Maybe I can fake an illness and stay home, and you can come play house with me and make me whatever you want. I'll make you whatever you want.
Publishing Exhibit 45, already in evidence.
You may.
Again, whose messages are in green?
Sherry's.
Could you read the defendant's messages to you out loud for the jury?
Yes. He just left for a long lunch with a friend. Want to come play Winky Face. I'll be upstairs. The door is unlocked. Just come in and come find me, Winky Face.
For how long were you having an affair with the defendant?
Through May, so about 6 months.
Whose idea was it to commit this crime?
It was Sherry's.
Did you make the defendant commit this crime with you?
No.
Did you threaten to kill her if she didn't commit this crime with you?
No.
Did you hold her at gunpoint?
No.
Well, let's talk about why she wanted to commit this crime. Did the defendant ever tell you about her relationship with her husband?
Yes.
What did she say?
She was unhappy with her relationship with her husband.
Well, if she was having an affair with you and she was unhappy in her relationship, did she tell you why she didn't just leave her husband?
Yeah, she told me she was financially dependent on him.
What did she tell you about her husband's finances?
He comes from a very wealthy family and he has a trust fund.
So what about her husband having a trust fund prevented her from leaving him?
I think they had a prenup in place, and if she left, she wouldn't get any of the money.
When did the defendant propose that you fake a kidnapping?
I think it was end of April sometime. I don't remember the specific day.
What day did she say you should fake the kidnapping?
It was May 9th going into May 10th that morning.
What time?
About 2 o'clock in the morning is when I got there.
When you arrived, where did you go?
I went to the back door.
Did you try other doors before you went to the back door?
Nope, went to the back door, just opened it. It was unlocked.
Well, why didn't you try any other doors?
I knew the back door was going to be unlocked. Sherry told me she was going to unlock it.
After you went in the door that the defendant promised would be unlocked, where did you go?
I went upstairs to their bedroom.
Did you go in the bedroom?
Yes, I did.
Did you see anyone in there?
Yes.
Who?
Her husband was asleep in bed and Sherry was sitting beside him in bed.
When you entered the defendant's bedroom, did she scream?
No.
Did she shake her husband awake?
No.
Did she reach to call 911?
No.
What did you see her do?
She just kind of smiled at me when she saw me come in.
What happened next?
So then I had a floodlight with me and I turned that on and then started saying Aaron's name to wake him up.
Did he wake up?
Yes, he did.
What did you do next?
I told him to roll over onto his stomach and then Sherry zip-tied his hands behind his back.
After the defendant zip-tied her husband's hands behind his back, what did you do?
Then I went over to her and pretended to zip-tie her, and then we put goggles on Aaron.
What do you mean you pretended to zip-tie her?
I put zip ties, like made the sound so it sounded like we're zip-tying her.
Did you zip-tie her loosely?
I don't think I zip-tied her at all.
Mr. Collins, after you put the goggles on Mr. Dunn, what did you do?
Then I gave him something to drink. I gave him a NyQuil and diazepam combination to drink.
What did you do next?
I took him downstairs and told him that he had to pay $500,000 within the next 48 hours or he wouldn't see his wife again.
After you made that threat, what did you and the defendant do?
We just walked out the front door
You walked out of the front door to where?
to my car.
Did you get in the car?
Yes, I did.
Where did you guys go?
We met to my apartment.
When you arrived at your apartment, what did you two do?
We just hung out for a couple of days.
Did you hold her at gunpoint in your apartment?
No,
Did Mr. Dunn ever pay you $500,000?
no.
When Mr. Dunn didn't pay you that money, what did the defendant do?
She started getting really nervous.
Did she stay after 48 hours when that money didn't arrive?
No, at some point she left.
What's the last thing she said to you before she left?
She was saying that he isn't going to pay, we're going to get in trouble, we're going to get arrested, all that sort of stuff.
Pass the witness.
Cross-examination,
Yes, Your Honor.
you may.
Mr. Collins, on May 17th, 2023, the police came to your house, correct?
Yes, they did.
They had a search warrant.
Yes.
They had an arrest warrant, right?
I don't know if they had an arrest warrant at that time, but they did come to my house.
But in your house, wide open for everyone to see, the police found NyQuil.
Yes, they did.
The police found zip ties.
Yes, they did.
The police found duct tape.
Yes, they did.
The police found your gun.
Yes, they did.
The police found diazepam, correct?
Yes, they did.
In other words, they found Valium.
Yes.
And the police found goggles covered in duct tape, correct?
Yes, they did.
And you were arrested.
Yes.
You were arrested for aggravated kidnapping
Yes.
and attempted theft, correct?
That's correct.
Now, let's break those down. Aggravated kidnapping can carry a charge or a sentence of up to 10 years, correct?
That's my understanding, yes.
And attempted theft can carry a charge or a sentence of up to 20 years, correct?
That's my understanding, yes.
So at that point, Mr. Collins, you were looking at nearly 30 years in prison.
I think I was looking at 20 years in prison, but I'm not an expert, but yes, looking at serious time.
And so naturally, on May 17th, you did not speak to the police that day.
You're right, I did not talk to the police that day.
You spoke to your lawyer, right?
That's correct.
And you wanted a deal, correct?
Yes.
And you got that deal, Mr. Collins.
Yes, I did.
You got that deal despite all this evidence the police found.
Yes.
And you got that deal despite your 2016 felony assault conviction, correct?
That's correct.
And this deal reduced those two felonies to a misdemeanor.
That's correct.
And your sentence from that misdemeanor is 180 days, correct?
That's correct.
That's less than half a year, correct?
Yes.
Now, you claim that you claim you did not need the money for this kidnapping, correct?
I mean, Sherry wanted to start her wife over, and so we were going to use the money for that.
Well, we can agree that you have some big gambling debts, correct?
I mean, I have some gambling debts, yes.
And isn't it true that you cannot pay those on your own?
It's been tough at times to pay those, yes.
In fact, it's been so tough you've asked Sherry Dunn in the past for money, correct?
Yes, I have.
$2,500, correct?
Yeah, I think on one time there was $2,500.
And that wouldn't have been nearly enough, right?
The $2,500 on your own, you mean?
Yes.
Yes, there were more debts. Yes,
And Sherry Dunn did not give you that money, correct?
that's correct.
Now, you claim Sherry Dunn planned this whole scheme, correct?
Yes,
But we can agree they found the NyQuil in your house.
yes,
They found the zip ties in your house.
yes,
They found the duct tape in your house.
yes,
They found the diazepam in your house.
yes,
They found the goggles in your house, correct?
yes,
Now, you also claim that Sherry Dunn did not act under force, correct?
yeah,
In other words, that she did this voluntarily, right?
yes.
We can agree that you've been violent towards Sherry Dunn in the past.
There was one time where I grabbed her arm, yes.
Let's talk about that time. You grabbed her arm so hard, Mr. Collins, that you left bruises.
Yes,
And we can agree that you had a gun in your house too, right?
yes,
And you had that gun while Sherry Dunn was with you after the attempted kidnapping, correct?
yes.
Pass the witness, Your Honor.
All right, any further questions for this witness?
Yes, Your Honor.
You may.
Opposing counsel just asked you some questions about the different tools or supplies from this crime that were in your apartment. Whose idea was it to use zip ties as part of this crime?
Objection, Your Honor. Pursuant to Rule 611B, this is outside the scope of my cross-examination.
I'm going to overrule.
Yes, Your Honor.
Mr. Collins, whose idea was it to use zip ties as part of this crime?
It was Sherry's.
Whose idea was it to use NyQuil?
It was Sherry's.
Whose idea was it to use diazepam?
It was Sherry's.
Whose idea was it to use goggles wrapped in tape?
It was Sherry's.
Now, I want to take a moment to respond to this idea that you threatened the defendant so she'd commit a crime with you. Earlier, we talked about the text messages between you and the defendant.
Yes.
How many of those text messages include you threatening the defendant if she doesn't go along with a fake crime?
None.
Pass the witness.
All right. Anything further?
No, Your Honor.
You may step down, sir.
Thank you, sir.
State, may I call your next witness?
Yes, Your Honor. State calls Detective Gilpin.
Detective Gilpin, if you would please come forward. Sir, will you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. If you would please have a seat. You may proceed, counsel.
Thank you, Your Honor. Good afternoon.
Good afternoon.
Could you please introduce yourself to the members of the jury?
My name is Riley Gilpin.
Where do you work?
I work in the Waco Police Department.
What rank do you hold?
I'm a detective.
How long have you been a detective with the Waco Police
About
Department?
16 years as a detective.
Detective, how are you involved in this case?
I was assigned to respond to the initial call about the kidnapping.
Did this case take place here in McLennan County?
Oh, yes, McLennan County, yes.
Let's talk about your investigation. When did you start your investigation?
The morning of the alleged kidnapping, I guess, May 10th.
So from May 10th, how long did your investigation last?
About 3 weeks.
During your investigation, did you order any forensic testing?
Yes,
Did you conduct any searches?
yes.
What forensic tests did you order?
We ordered forensic tests on a number of items that we found in the various locations where the events occurred. Goggles, taser. We did some investigation. There was a gun found. Other sort of the drugs that were found at the defendant or at Mr. Collins' apartment. We did blood tests. We examined Mr. Collins' automobile. We examined the bedroom where the alleged kidnapping took place, and then we examined other places in the Dunn's residence.
Detective, can I ask you to move just a little closer to the microphone so that we can all properly hear? Thank you,
Certainly.
counsel. You may proceed.
Thank you, Your Honor. You said you searched several locations as part of your investigation. Can you tell the jury where you searched?
We searched the Dunn's home and Mr. Collins' apartment and Mr. Collins' automobile.
Did you interview witnesses as part of your investigation?
Yes,
Which witnesses did you interview?
both Mr. and Mrs. Dunn and then Mr. Collins.
I want to respond to this idea that the defendant committed this crime because she was threatened or under duress. Now, when did you interview the defendant?
May 13th.
When you interviewed the defendant on May 13th, where did she say she'd been for the last 3 days?
She said she had been in a closet in somebody's, what she thought, apartment for the last couple of days. But she wasn't exactly sure where that was.
Well, I want to break that down. During this interview, did she say she helped Matthew Collins commit a crime?
She did not.
Did she say, Matthew Collins made me do this?
She did not.
Did she say she was held at gunpoint?
She did not.
Did she say threats were made against her life if she didn't go along with this kidnapping?
She did not.
How many times did she say the word gun?
Not once.
How many times did she say the name Matthew Collins?
Not once.
What did she say about the identity of her kidnapper?
She did not know who it was. She did not recognize the person's voice, so she had no basis for even speculating as to who it might be.
I want to be clear about the circumstances of this interview. Well, where did it take place?
The initial interview took place in the department office.
So during this interview, was Matthew Collings pointing a gun at the defendant?
He was not there, no.
Was Matthew Collings in the room at all?
He was nowhere near, no.
Who was in the room when the defendant said she didn't know the identity of her kidnapper?
Myself, her attorney, and Ms. Dunn.
Who was in the room when the defendant said she was kidnapped?
Myself, her attorney, and Ms. Dunn.
Thank you, Detective. Pass the witness.
Cross-examination.
Yes, Your Honor.
You may proceed, sir.
Detective Gilpin, we can agree that Sherry Dunn was not honest with you during your first interview.
As it turns out, yes,
We can also agree that Matthew Collings had not been detained yet, correct?
that's right.
He was still free here in this town.
That, as far as I know, yes.
And you did not station a police officer outside the Dunn home, right?
I did not.
And you could have done that, correct?
If the circumstances called for it, yes, but there was a security camera, so we had that turned on.
But we can agree that you left the Dunns at home alone, right?
Yes.
Now, Sherry Dunn did speak to you, right?
After we spoke to her husband, she came in, yes.
She spoke to you not once, but twice, right?
We asked her to come back, yes, and we found information that contradicted her original statement.
And Sherry Dunn also gave a blood sample, correct?
She did.
And she never asked for a deal, right?
No.
You also spoke to Aaron Dunn.
Yes,
Aaron Dunn gave a blood sample.
he did.
And then you spoke to Matthew Collings on May 17th, correct?
Yes.
But Matthew Collings did not speak with you. Matthew Collings did not submit to your questions, correct?
No, right.
He said he wanted to speak to his attorney.
Yes,
He said he wanted a deal, right?
yes,
And on May 18th, he still refused to speak to you until he got his deal.
that's right.
And that was at 10:15 a.m. on May 18th.
Yes, I believe that's right.
And he had a deal by 3:45 p.m. that same day.
That's right.
And that deal reduced his felony charges to misdemeanors.
That's my understanding. I did not negotiate the deal.
Now, those felony charges were aggravated kidnapping, right?
That's right.
And it can carry a sentence up to 10 years.
Possibly, yes.
And it was also attempted theft.
That's correct.
It can carry a sentence up to 20 years.
That's correct.
But his misdemeanor carried a sentence of 180 days.
That's right.
180 days after you searched his apartment, right?
Yes,
180 days after you found this gun in his apartment,
I believe that's the gun, yes.
this NyQuil,
Yes,
these pills,
yes,
these zip ties,
yes,
this taser,
yes.
and these goggles.
I believe those are the ones we found there.
180 days after he admitted to drugging Aaron Dunn.
Yes,
180 days after he admitted that he committed this kidnapping, correct?
Again, that's not my doing, that's the DA's doing. So, I mean, if you're asking me whether that was my idea, no, it was the DA who cut that deal.
Well, let's talk about some of your investigation. We can agree that it's important to validate what an eyewitness says, correct?
That's common
Especially when that person is a co-defendant.
Yes.
Mr. Collings was a co-defendant at the time he was arrested.
Well, he hadn't been charged yet.
Well, we can agree that you needed to corroborate what he says.
Yes,
And details help you do that, right?
yes,
And he could have given you the details about what happened in his apartment after the kidnapping.
yes.
But you said you didn't need any of the details, correct?
Well, I didn't say that.
Is your testimony today that you said you did not say you didn't need any of the details?
We said we didn't need to go further until he talked to the DA.
But just to be clear, and Detective Gilpin, you said you didn't need any of the details about what happened in that apartment for those few days, correct?
At that point, yes, because he was going to talk to the DA.
So are you saying that the details are not important to your investigation after that point?
That's not what I said, no.
You didn't collect those details, correct?
Well,
So once he cut a deal with the DA, we can agree you didn't investigate Mr. Collins anymore.
That's usually the way it works.
And so no more time was spent in your investigation for Mr. Collins.
The record is what it is.
Now, we can agree that someone can do something under the force of another, right?
Yes.
And someone can be put under the force of another with just verbal threats, correct?
Depending on the circumstances, sure.
And someone can be put under the force of another using a gun, correct?
Yes,
You found a gun in Mr. Collins' apartment, right?
I did.
Your Honor, pass the witness.
Any further questions for this witness?
Yes, Your Honor. May I proceed?
You may.
Opposing counsel just asked you whether you investigated the possibility that the defendant committed this crime because she was under duress. Did you investigate that possibility?
Yes.
In what way did you investigate?
Well, we questioned her about the circumstances.
And when you questioned her about the circumstances, did she indicate she was under duress?
She made no indication whatsoever.
Pass the witness.
All right, this witness may step down. Thank you, sir. You may step down. Additional evidence from the state at this time?
No, Your Honor. The state rests.
All right. I believe we need to take a short recess at this time. So let's take a 5-minute recess. Jury, you may be excused for that 5 minutes. Well, constructively excused at this time.
Your Honor, before we break for recess, would you mind if we took up a substantive motion outside the presence of the jury?
And that's what we'll do at this time. The jury is constructively out of the room.
Your Honor, pursuant to Rule 29 of the Federal Rules of Criminal Procedure, and viewing the evidence in the light most favorable of the non-moving party, which is the prosecution in this case, the prosecution has failed to provide sufficient evidence to sustain a conviction. Specifically, Your Honor, on their claim of attempted theft, as they have not shown that the defendant, Sherry Dunn, made any substantial step towards appropriating the $500,000 from Aaron Dunn. Therefore, we respectfully move that this court grant our motion for judgment of acquittal.
Do you wish to be heard, sir?
Yes, Your Honor. The Rule 29 motion should be denied. Viewing the evidence in the light most favorable to the state, a reasonable juror could certainly convict the defendant. We have established that there was an attempt to take more than $300,000 because Mr. Collins on the stand testified he was directed by the defendant to ask for $500,000. Mr. Collins' testimony alone allows the state to meet its burden. If opposing counsel raises issues of credibility, that's not sufficient for a Rule 29 motion. Credibility issues are reserved for the jury to determine. The motion should be denied.
All right, thank you. I'll take it under advisement. At this time, I deny the defense motion. Let's take that 5-minute recess and we'll begin the defense case in chief.
Sounds
Yes,
good,
Your Honor.
All right, we are back on the record. The jury has now assembled. It's time for the defense. Do you have a witness you wish to call at this time?
Yes, Your Honor. The defense calls Sherry Dunn to the stand.
All right, Ms. Dunn, would you please come forward? Would you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? If you would, please have a seat. And adjust that microphone however you need to be heard best, please.
Yes, Your Honor.
And you may proceed, counsel.
Thank you, Your Honor. Good afternoon, Ms. Dunn. Could you please introduce yourself, spelling your last name for the record?
Yes, hello. My name is Sherry Dunn. My last name is spelled D-U-N-N-E.
Now, before we begin today, Ms. Dunn, do you understand that you have a constitutional right not to testify?
Yes, I do.
Do you further understand that if you chose not to testify today, that could not be held against you?
I do.
And do you understand by testifying today, you're opening yourself up to cross-examination by the state today?
I do.
With all of that in mind, Ms. Dunn, why did you decide to take the stand today?
I wanted to get up here and tell the truth about what happened, give my side of the story.
I'd like to give you a moment to introduce yourself to the jury. Now, where are you from?
I'm a Waco local, so I'm from here.
And are you married?
I am, yes.
How long have you been married?
For about 8 years now.
And who are you married to?
Aaron Dunn.
Now, can you just describe your relationship with your husband to the jury?
It's a happy marriage. I mean, no marriage is perfect, so we have some issues and some arguments sometimes, but I love my husband, so it's been very happy years.
Now, you mentioned that you have some issues. What are some of those issues?
We'll have sometimes some financial disagreements.
Now, what do you mean by financial disagreements, Ms. Dunn?
Well, typically I get an allowance from the trust fund every month. And so sometimes if my friends wanted to go out a lot a particular month and I ran out of money, I would have to go and ask. And so on those months, sometimes we would just disagree on that.
Now, Ms. Dunn, this may be uncomfortable, but have you ever been unfaithful in your marriage?
I have, yes.
With who?
Matthew Collins.
Now, when did this begin with Matthew Collins?
It started around November of 2022.
And how long was your affair with Matthew Collins?
It was about 6 months, ended around May of the following year.
And how would you, Ms. Dunn, how would you describe your relationship with Matthew Collins?
It started at a bar. It was something new at the time. At the beginning, it felt exciting, but, that just quickly turned.
And we'll get to that in a minute, Ms. Dunn, but I want to talk about just some more of your relationship with Mr. Collins. Did you ever share any of the struggles that you mentioned earlier with your husband with Mr. Collins?
Yes, I unfortunately made the mistake of opening up to Matthew about that.
Did you open up to Matthew Collins about your husband's financial status?
I did, yes.
Now, was there ever a point where in your relationship with Matthew Collins where you began to discuss what happened on May 10th, 2023?
Yes, we were at Scruff's one night when he brought it up.
Now, for those of us who do not know, what is Scruff's?
Yeah, Scruff's is a local dive bar here in Waco. I think the full name is Scruffy Murphy's, but we all just call it Scruff's.
And in this first conversation, what did Mr. Collins bring up?
Oh, this is when he kind of came up with the idea of, well, maybe your husband might pay for a ransom. And that's how, we could get some money.
Now, after he pitched this to you, Ms. Dunn, how did you react?
I laughed at it. It was a ridiculous idea. And that's exactly what I told him.
After this first time he brought this up at Scruff's, did he bring it up again?
Yes, he did.
And how did you react the second time he brought it up?
So the second time, I believe we were also at Scruff's, but this time I also tried to laugh it off, tell him it was still ridiculous, but this time it was different.
How was it different, Ms. Dunn?
Well, the first time when he brought it up, he just kind of mentioned it as a random idea, but this time he had a plan. He knew exactly how it was going to go down. He had a strategy. This didn't seem like a joke anymore.
How did you respond to this plan?
I tried to tell him the same thing, like this wouldn't work, this had to be a joke, but he didn't take my reaction well.
Well, what do you mean by he didn't take your reaction well?
Well, when I said that, just something flipped. The way he looked at me, and then he just pulled me closer, and that's when he threatened me.
Well, what was his specific threat, Ms. Dunn?
He told me that I was going to help him because he knew where I lived, he knew where I slept, and if I didn't, he would kill me.
Ms. Dunn, how did you feel in that moment in Scruffs when Matthew Collins said that to you?
I was shocked and horrified and I was scared. I didn't know what to do.
Did you have reason to believe that Matthew Collins would act on these threats?
Yes, I did.
And what were those reasons?
Earlier that year, we had a fight, and during that fight, things escalated. He grabbed my arm, and he actually left bruises that stayed the entire week, and I had to cover them up.
Did you discuss these bruises via text message with Mr. Collins?
We did.
Your Honor, state publishes to the jury what's been pre-admitted as Exhibit 49.
All right, you may.
Now, Ms. Sizemore, if you could focus in on these texts, thank you. Ms. Dunn, could you describe this text message? Actually, could you just read this text message conversation to the jury?
Yes, so Matthew is the person in gray, and he just said, "Hey, sorry about last night. I just lose my temper sometimes, but you know that. I'm sorry if I scared you." And I answered, "You did a little more than scare me. Good thing it's cold outside because I needed a sweater to cover the bruises on my arms from when you grabbed me." Then I said, "WTF?" It said question marks. And he said, "I know, I'm really sorry, and it won't happen again." And that's when I asked him for a few days to just think about it. I needed some time.
Now, let's turn back to that second time at Scruffy's where Mr. Collins threatened you. Now, after he had laid out his plan and he had threatened you at that point, did you ever meet up with Mr. Collins again?
Yes, we met up one more time.
Now, Ms. Dunn, why did you not go to the police at that point?
At that point, I was scared. I thought maybe if I just humored him, this would be the quickest way to get him out of our lives. You know, I brought him in it. I was scared he would hurt me or Aaron.
Did you meet in person with Matthew Collins again?
Yes.
And where did you meet in person?
This time we met at a motel.
And did he threaten you again in that motel?
Yes. You know, this time he said the same thing, that I was going to help him, that I better not screw it up. I better not go to the police, or he would kill me and Aaron. And this time he had a gun.
Now, what did Mr. Collins do with this gun?
He kind of just had it always near him, just kept playing around with it the entire time as the conversation was going on.
How did you feel in that motel room with Mr. Collins?
I was just scared. I had never been so scared up until that point. You know, all of his threats, you know, I was thinking about myself, about my husband. It was a nightmare.
And after this night in the motel, did you continue to go along with Mr. Collins' plan?
I did.
Miss Dunn, why did you not speak to the police, or why did you not tell your husband?
It all just kind of went back to his threats of me telling anyone, of me not screwing it up, or he would do something. Looking back, I can see my mistakes. I can see what I should have done. But back then, I just wanted to get me and my husband through it.
Now let's move on to May 10th, 2023. Did you do anything to prepare for that attempted kidnapping that night?
I did. As per Matthew's instructions, I turned off kind of like our Ring camera that we have in the front, and I unlocked the back door.
And was there ever a point where you heard Mr. Collins come to your home?
Yes, I can't remember the specific time, but at some point in the middle of the night, he came in.
And did he come into your bedroom?
He did.
I'd like to talk about the moment that he came into your bedroom, Your Honor. Permission for the witness to step down for the demonstrative purposes.
You may.
Now, Ms. Dunn, for the purposes of this demonstrative, I want you to pretend as if you were Mr. Collins that night coming into your room. Now, when he arrived in your room, what was the first thing that he did?
This is when he just showed me that he had a gun on him.
And after he showed you the gun, what did he do with it?
And he kind of put it away kind of like in his hands, but I could still see it.
And About how far was Mr. Collins away from you?
He was about 6 feet, a little bit bad, it says, but kind of around the same distance that you and I are at.
And what did Mr. Collins do next?
I believe this is when he asked me to zip tie my husband.
Thank you, Ms. Dunn. You can return to the stand. Now, you mentioned that he asked you to zip tie your husband. After you did that, what happened next?
After this is when I believe he put the goggles on Matthew. This is when he drugged him. And then we moved him downstairs, and this is where he threatened and asked for the money.
Now, when you were downstairs, did you two leave the house at any point?
Yes, we did.
And where did you go?
We went to Matthew's apartment.
Now, when you got to Matthew's apartment, about how long of a period were you there?
It was about 2 days.
And during those 2 days, did Matthew Collins continue to threaten you, Ms. Dunn?
Yes, he did.
And what type of specific threats did he make against you at his apartment?
He would just turn around, tell me like, he knows, like Aaron knows I'm serious about this, right? Like I'm not joking. Maybe I should send him one of your toes so he can see how serious I am about this.
Now, you said that he had that gun in the motel and he had that gun in your home. Did he have that gun in his apartment during those 2 days?
Yes, he still had the gun.
And were you worried for your safety while you were in that apartment with Mr. Collins?
Absolutely, I was.
Why is that?
I knew he had a violent past. He had hurt me before. I believe
Objection, Your Honor, to character evidence. May I explain?
You may.
The witness said she was afraid of the witness, of Mr. Collins, because he had a violent past. This is propensity evidence under 404A.
Your Honor, may I respond?
You may.
Your Honor, this is not being offered for a propensity purpose under Rule 404A. Rather, it's being offered to show the defendant's motive in this case. And as Your Honor knows, we have the burden to prove the duress defense today. And this speaks directly to the witness's intent that she firmly believed that Mr. Collins would act against her to perform imminent threats of substantial bodily harm or death, Your Honor. This is not being offered for a propensity purpose.
I'm going to overrule the objection.
I'm going to ask my question again, Ms. Dunn. Were you worried about these threats in your apartment?
absolutely. Like I said, I knew he had a past. He had already hurt me before. He had made me zip tie, and he drugged my husband, and he had made specific threats of what he would do to me if I messed up.
And was there ever a point where you were alone in this apartment?
Yes, he left the apartment after about 2 days of being there.
And what did you do when you were finally alone?
I ran, I left, I went home.
When you arrived home, did you call your husband?
I did.
Did he come home as well?
Yes.
And when he came home, did you tell him the complete truth about what happened to you at Matthew Collins' apartment?
No. At that point, after the past 2 days, I just couldn't bring myself to tell him that it was my fault.
Why is that?
You know, despite what I did, I love my husband. He's a great man, and I brought this awful person into our lives because of a mistake that I made.
Now, when you arrived back home on May 12th, 2023, did you have an opportunity to speak to the police?
I did, yes. I went in voluntarily the day afterwards to speak with them.
Did you tell the police the complete truth about Matthew Collins?
No, I didn't.
Why did you not tell the police the complete truth?
Matthew was still out there. I was scared that if he found out that I told the cops about him, that he would know that it was me and that he would follow through with his promises and that he would come back and finish the job.
Did you have any protection offered to you by the Waco Police Department?
No.
Ms. Dunn, please tell this jury, why did this all happen to you?
This all happened because I made a dumb mistake one night at a bar, and it spiraled into something awful. And by the time that I realized how bad it was, how dangerous he was, I was stuck.
Thank you, Ms. Dunn. Your Honor, pass the witness.
Cross-examination.
Yes, Your Honor.
You may proceed.
I want to start by talking about why you did this. Your husband has a trust fund, right?
He does.
You two lived off that trust fund,
Yes.
but you didn't have access to the trust fund.
No, like I said, I got a monthly allowance from it.
That's right. Your husband gave you an allowance of $5,000 a month.
Yes.
You didn't always think that was enough, did you?
No, I didn't.
Sometimes your card got declined.
Yes.
Sometimes you had to beg your husband for money.
Yes.
You didn't like begging your husband for money.
I don't think anyone likes begging.
You thought $5,000 was a rounding error for his family.
Yeah.
But your husband, he never increased your allowance, did he?
No, he didn't. You know, on some months, if I needed something extra, then we could work something out. But it stayed at the $5,000, yes.
So let's talk about your role in this crime. On May 10th of 2023, you knew Matthew Collings was coming to your house, right?
I did.
You knew he was bringing tools with him.
I did.
You knew he was going to ask for $500,000 in ransom.
I did.
You helped him do it.
I did. I followed his instructions to keep my husband safe.
You turned off the security camera for Mr. Collings.
That's correct.
You left the door unlocked for Mr. Collings.
That's correct.
You pretended to be kidnapped for Mr. Collings.
Yeah.
You pretended that you were a victim of kidnapping.
I wouldn't say I pretended to be a victim. He did hold me in his apartment for 2 days, telling me that if I messed up or called anyone, he would kill me.
Well, hold on. You told the police that you didn't know who the intruder was, right?
That's correct.
You told the police he came in the middle of the night and took you, right?
Yes.
That wasn't true, was it?
No, it wasn't.
So let's talk about this duress defense that you told the jury about. Now, you said that you were afraid of Matthew Collings, right?
Yes.
You said you were afraid of him because of a time when he had bruised your arm, right?
That's when it started, and then it continued to escalate.
Well, I want to talk about that. Your Honor, publishing Exhibit 49.
You may.
Mrs. Dunn, this is the text message you told the jury about on direct examination, right?
Yes.
I want to focus on the date on this text message. This text is from February 20th, right?
Yes.
This kidnapping that you helped Mr. Collings fake, that was in May, right?
That's correct.
So let's talk about how you responded to this message. Publishing Exhibit 53. You texted Mr. Collings at the start of March, right?
Yes, that's correct.
You said, "It was great seeing you today," right?
Yes.
Great's in all caps.
Yes.
And not just for the obvious reasons.
Right.
I appreciate you hanging out and talking through things I know I'm annoying, right?
Yes.
You're not claiming that you were first threatened by Mr. Collings on May 10th, right?
No.
You're not claiming you were first threatened by him on May 9th.
No, it happened. It started a few weeks before.
So, Mrs. Dunn, we can agree there was a period of time between when you were threatened and when you helped Mr. Collings fake this kidnapping.
Sure.
And in that period of time, you didn't go to the police, right?
I didn't. At that point, from the first time he brought it up, weeks before, he had threatened my life, and I was scared.
We'll talk about that later. You didn't go to the police after he threatened, right?
No, I didn't.
Well, let's talk about whether you said this was duress after the kidnapping. Now, you came home on May 12th, right?
That's correct.
You spoke to Detective Gilpin on May 13th.
Yes.
When you spoke with Detective Gilpin, you said you didn't know who had kidnapped you.
That's true.
You said you didn't help them get in.
That's true.
So when you spoke with that detective, you didn't say, listen, I helped Mr. Collins commit this crime, right?
No, I didn't.
That whole history of threats you just tried to tell the jury about, you didn't say any of that to the police, right?
No, I didn't. Matthew had threatened me that if I involved the police, he would kill me. At that point, he wasn't in custody. He was still out there. He had a gun. I know it was a mistake. I know that now. But back then, I didn't think I had a choice.
Well, you say you didn't think you had a choice. This interview happened in a police station, right?
Yeah, that's true.
In a room
Yes,
where Mr. Collins was not.
that's correct.
He wasn't pointing a gun at you as the police asked you what happened, right?
Not literally, no.
Not literally. He wasn't there, right?
He was not there, but those threats had still happened. He still knew where I lived. So, no, he wasn't there at that time, but he could have still have wanted to hurt me.
But not right then, right?
No,
It'd have to be later, right?
sure.
It wasn't imminent.
No, he wasn't at the police station in the room when I spoke, no.
Let's talk about what you did tell the police. We can agree you lied to them, right?
We can, yes.
Not just once,
No,
not just twice.
no.
You lied over and over again to the police, right?
That's correct, I did.
Let's list out a few of them. You told the police that you never had an affair, right?
Yeah, I like I said, I was embarrassed.
So that was a lie.
Yes,
You told the police you couldn't recognize the voice of the person who kidnapped you.
correct.
That was a lie.
Yes,
You told the police that you were in his trunk, right?
yes,
Locked there,
yes,
blindfolded,
yes,
zip tied.
yes.
None of that was true.
No,
They were all lies.
yes.
Pass the witness.
Further questions for your witness?
Yes, Your Honor.
You may.
Ms. Dunn, on cross-examination, you were asked about a period of time between the threats that Mr. Collins made and the kidnapping where you didn't go to the police. Was there any specific reason you did not go to the police during those times?
Yeah, just the fact that he specifically said that if I went to the police, that he would kill me or my husband. Now, I wish I had gone, but back then, he could have gone into my house. He could have waited for me outside. He could have got an errand while I went to the police. If he found out, I messed up, and I was too scared to do so.
Thank you, Ms. Dunn. Pass the witness, Your Honor.
All right. Any further questions?
Yes, Your Honor.
Okay, briefly.
Mrs. Dunn, on May 13th, you went to the police voluntarily, right?
Objection,
correct.
Your Honor. Pursuant to Rule 611B, this is outside the scope of my redirect examination. I asked about the period of time in between the threats that were made before the kidnapping and May 10th, 2023, and opposing counsel is asking about something that happened on May 13th.
Response, Your Honor?
You may.
Rule 611 isn't just about the temporal period that opposing counsel asked about. It's about the topic. And he redirected the witness about why she didn't go to the police. The fact that she went to the police voluntarily undermines that argument. It's within the scope.
I'm going to allow it.
Yes, Your Honor.
So I'll ask you again, Mrs. Dunn. On May 13th, when you told us that Mr. Collins was still out there, you went to the police voluntarily. Isn't that a fact?
I did.
Yes or no, Mrs. Dunn? You went to the police voluntarily.
I did. After I got out, back home, when I talked to my husband, he said that the police had actually accused him of murdering me and of him harming me.
Your
So I
Honor.
wanted to go and clear it up.
Just a moment, Mr.
Your Honor, motion to strike everything after I did.
Granted.
Pass the witness.
All right. Anything further?
No, Your Honor.
You may step down.
Yes, Your Honor.
May call your next witness.
Your Honor, the defense rests its case.
All right. At this time, we'll need to have a matter outside the constructive presence of the jury, and then we'll take a brief recess. Have the parties conferred about the charge, and are you ready to present that to the court at this time?
Your Honor, if we may have a brief moment to confer.
Take a moment and then let me know.
Correct?
You're on. Duress defense to witness test.
Thank you. Okay, yes?
Your Honor, we will be submitting to the jury charge of the duress defense with the defendant testifying.
Okay, very well. Let's stand in recess for a few minutes while we accomplish that. And the jury, you may be excused at this time if you need to step out. We're in recess. is going to be an issue. So how much time would each side like for argument?
Your Honor, I believe we have upwards of 30 or 40 minutes.
Right, so how much time do you want for argument?
I think we'll reserve 20 minutes to play it safe, but we shouldn't come close to it, Your Honor.
All right, and you'll be,
That will be the same, Your Honor, for us.
all right. Then we'll proceed. Before we bring the jury in, are there any other matters to take up outside the presence of the jury?
Your Honor, I will renew my motion for judgment of acquittal under Rule 29 based on the same grounds in mid-trial.
All right, and I'll deny that at this time. The jury charge has been agreed upon. I will bring in the jury and constructively read that charge to them, at which time we will proceed with closing arguments. Is the state ready to proceed in that manner?
Yes, Your Honor.
And the defense?
Yes, Your Honor.
All right, the jury has been brought back into the courtroom at this time. I have constructively read the jury charge to the jury, and state, you may proceed with your summary argument.
At the beginning of trial, I told you we would prove the defendant's guilt with 3 key facts. I was wrong. We only needed 1. The defendant admitted she did it. She admitted the exact thing we've been telling you all trial. She admitted she wasn't a victim of this kidnap. She was in on it. As the state, we had the burden of proof in this case to prove the defendant's guilt beyond a reasonable doubt. Now, members of the jury, I could walk you through all the evidence. The text messages we heard about from Detective Gilpin, his searches, the forensics. I'm not going to waste your time. The defendant admitted everything on her cross-examination. Let's go through a list of the things she admitted on her cross. She admitted her role in this crime. She admitted she knew Matthew Collins. She admitted she knew he was coming on May 10th. She admitted she knew the plan. She admitted the plan was to get $500,000. She admitted she didn't call the police. Admitted she turned off the security cameras. Admitted she left the back door unlocked. She admitted she only pretended to be kidnapped. This is the verdict form. As the judge will explain, we had to prove that the defendant committed attempted theft. Attempted theft is committed when the defendant intended to take money from her husband and took a substantial step towards the commission of that crime. The defendant admitted their plan was to get $500,000 from Mr. Dunn. And we showed you she took substantial steps towards committing that crime. When she left the door unlocked, when she turned off the security cameras, when she zip-tied her husband's hands. We've met our burden on attempted theft. You can mark guilty. The second charge, aggravated kidnapping. Now, as I told you in opening statement, it may sound a little unusual to say that a person's kidnapped when they never leave their home. But these are the 4 elements. 1, that the defendant intentionally or knowingly restrained another person's movements. You heard about zip ties and drugs, sedation. Mr. Dunn's movements were restricted. 2, this was accomplished by force, intimidation, or deception. Now, That's an or there in number 2, but we've got all 3. Force, zip tying his hands. Intimidation, saying that Mr. Dunn's wife would be killed. And deception, when the defendant was part of it the whole time. Number 3, the defendant interfered substantially with the other person's liberty. Again, zip ties, drugs. Mr. Dunn's liberty was substantially interfered with. And number 4, the defendant did this with the intent to facilitate the commission of a felony. This was all to get ransom money, $500,000, a plan the defendant knew about from the beginning. You can mark guilty to aggravated kidnapping. So all that's left is this duress defense, that Mrs. Dunn, the defendant, was threatened. That's the only reason she did this. But these are the jury instructions. You'll learn that to establish a duress defense, it's not the state that has the burden of proof. The defendant has the burden to establish they were, in fact, under duress, more likely than not. They were unable to meet their burden. Their duress theory, the first problem with it is that it's not the law. Think about the story that Mrs. Dunn, the defendant, told you on the stand about these threats. Remember, in the jury instructions, a duress defense only works if it involves the imminent loss of life or serious bodily injury. Imminent, folks. Nothing about the story she told involved an imminent threat. The cornerstone of her whole "I was threatened, I was in danger" idea came from an incident on February 20th, where her arms were bruised. Now, members of the jury, I don't want to dismiss for a moment how serious something like that is. But the problem is, the defendant did dismiss it. We showed you her text messages from a few days later. Excited to see him, excited to go do things. So that February incident, it's not an imminent threat that causes someone to commit a crime under duress in May. Now, defense would say, and I expect they'll tell you, that there were more threats, that she was threatened at a bar, that they went to a motel, there were threats there. Folks, these are not imminent, because the defendant admitted on the stand. There was a period of time between those threats and when she pretended she was kidnapped. She could have gone to the police. She could have gone right to the authorities, and instead, she went along with it. The second problem with this duress defense is that it requires you to believe the defendant. Here's a partial list of all the lies the defendant told the police, rather. She told the police, "I never had an affair." That was a lie. She said, "I didn't know who the intruder was." That was a lie. She said she didn't recognize his voice. That was a lie. She said she had no idea how he got in that night. She said she was put in the trunk. Lie, lie, lie. On the direct examination of the defendant, defense counsel kept saying something interesting. He would say, "Man, was that the whole truth?" Folks, these are not incomplete truths. These aren't half-truths. She wasn't leaving things out. She was making things up. If she would lie so willingly to the police, to her husband, what makes you think she wouldn't lie to you? But the third problem, the biggest problem with this duress defense, folks, it's not true. This whole defense is premised on the idea that she was too scared to go to the police, that if she went to the police, Mr. Callings would kill her. And they made a big point that Mr. Callings, well, he was still out on the loose. He wasn't arrested until May 17th. But then, we learned the defendant went willingly to the police on May 13th. Went in to have a chat. That doesn't make any sense, folks. You can't have it both ways. If she went in willingly to talk to the police, then no. She wasn't under enough duress, enough imminent risk of life to excuse what she did. The defendant didn't do this because she was afraid. She did it because she was greedy. She did it because she didn't think $5,000 a month out of a trust fund was enough. She thought it was an insult. She thought it was a rounding error for the Dunns, and she was sick of begging for money. The defendant was not the victim. She was in on it. Now, in just a moment, I expect the defense will get up here and they'll say, well, you cannot believe Matthew Callings. He's a convicted felon. He's here on a plea deal. So I want to point something out. I haven't referred to his testimony once. Let me say that again. In my closing argument, I haven't referred to Mr. Callings' testimony once. Because the defendant admitted what she did. Find her guilty of attempted theft and aggravated kidnapping. Because she wasn't the victim. She was in on it. Thank you for your time. Thank you, Your Honor.
The defense may go.
May I proceed, Your Honor?
You may, sir.
May I prepare the well?
You may. Take a moment.
You now know, members of the jury, that that horror, that shock, that fear that was felt in the Dunn home not only was felt by Aaron Dunn, but it was felt by Sherry Dunn. And the prosecution today has the burden of proof in this case. And members of the jury, they have failed to meet their burden of proof beyond a reasonable doubt for each of their elements. And you do not have to look far for reasonable doubt in this case. All you have to do is look to the indictment, members of the jury. You'll get a copy of it when you go back to your jury room, and I want you to see who's listed as the victim in this case. Aaron Dunn. Now, the prosecution had every opportunity to call the victim so that they could tell you what happened on May 10th, 2023 from their perspective. Ask yourselves, members of the jury, why did they not call the victim of this crime they have charged? They don't want you to hear from the victim. They don't want you to hear why he's still married to Sherry Dunn. They failed to provide that evidence to you. And what was the only evidence they brought? Matthew Callings. And I wrote something down too that the prosecution said. They said it really early in their case, in opening statements. They said no one is excusing Matthew today. But what you learned is that Matthew Collings is bought and paid for by the prosecution. He was excused. He was excused of 29 and a half years of prison time for testifying today, members of the jury. After all of the physical evidence in this case was found in his apartment, the NyQuil, the pills, the diazepam, the zip ties, the goggles with the duct tape on them, the taser, the gun, members of the jury. They cut him a deal after all of this. And you know that Matthew Collings had a motive to participate in this crime and to plan this crime. You heard about the gambling debts. You heard that he was in tough times and couldn't pay his debts on his own. And who did he reach out to pay his debts? Sherry Dunn, and she said no. Members of the jury, Matthew Collings should bring you reasonable doubt. But the fact of the matter is, if the prosecution meets their burden of proof today, this case is not over. Because we have also brought an affirmative defense of duress. And let's look at that together, members of the jury. If an affirmative defense to the prosecution for any offense that a person charged engaged in prescribed conduct because she was compelled to do so by threat of imminent death or serious bodily injury to herself or another. And the prosecution is right. We have a burden of proof for that duress defense, and it's a preponderance of the evidence. Now, what does that mean? Well, you can think of it like a test you took in school, members of the jury. And we took that test today for our affirmative defense, and to pass our test, we do not have to score a 90. We do not have to score an 80. We do not have to score a 70. We simply have to score a 51. We have to show you that it is more likely than not that Sherry Dunn was under imminent threat of serious bodily injury from Mr. Collings. We met that burden today. And ask yourselves, when did that imminent threat start? It started at Scruff's, right here in town. When Mr. Collings laid out this plan, he was the perpetrator behind this plan. And how do you know it? Because all of the evidence, members of the jury, was found in his home. That's undisputed. Everything was found there. And how did he get Sherry Dunn to go along with his plan? With threats. Threat after threat after threat, starting in Scruff's. And you heard why Sherry Dunn told you she believed those threats. It's because before, Matthew Collings had made her have to cover up bruises on his arm, or on her arm. And the prosecution tried to minimize that today. That she was not under imminent threat, that she did not believe that he would act on those threats after she was a victim of domestic violence. That's what they want you to believe. That should be enough to show duress, members of the jury, but we showed you more. We showed you what happened in the motel room. We showed you how Matthew Collings brought the gun, threatened Sherry Dunn with the gun. Not just once in the motel room, but where else? On May 10th, 2023, he continued to threaten her with the gun. She came off the stand and she showed you today. Matthew Collings made sure that she knew he had a gun and that she needed to comply with his scheme. And she was in fear of her life, and she was in fear of her husband's life. In that moment, you know for sure that was imminent. He was 6 feet away with a gun. And was that the only threat, members of the jury? No. The threats continued in that apartment with this gun and with specific threats that he would remove her toes and mail them to Aaron Dunn to get him to pay the ransom. That was part of Matthew Collings' threats. That caused imminent fear. Sherry Dunn told you it did. But the prosecution, they want you to believe that she wasn't under duress. They point to the inconsistent testimony and stories she told police. Sherry Dunn told you why those stories were inconsistent. And although Matthew Collins was not in that interrogation room holding this gun to Sherry Dunn's head, all the memories of the threat after threat after threat that started in February of 2023 were in her head. And she knew that he was still in Waco, free. And what else did she know? She knew Matthew Collins had this gun, and she knew that Matthew Collins knew her address. She was in fear, members of the jury. She felt horror, she felt shock, she felt imminent threat from Matthew Collins, and she didn't feel like she could get out. That's why I ask you to return the only verdict that the evidence demands today, a verdict finding the defendant, Sherry Dunn, not guilty. Thank you.
All right. Mr. Jones,
Yes, Your Honor, rebuttal?
you may.
The defense wants to make this case into a he said, she said. What Matthew Collins said versus what the defendant said. It's not a he said, she said. It's a she said, she said. What the defendant told the police versus what the defendant told you. She told the police, I have no idea who broke into my house. She told you, it was my boyfriend. She told the police, I have no idea how he got in. She told you, I unlocked the door. She told the police, I was kidnapped. She told you she was only pretending. Their entire defense depends on you believing the story of a defendant who can't keep her story straight. She lied to the police, she lied to her husband, but we're supposed to believe she told the truth to you? Don't buy it. Find the defendant guilty because she was not the victim. She was in on it. Thank you. Thank you, Your Honor.
All right, thank you both. At this time, I'll excuse the jury to deliberate. I believe you'll go with the bailiff. And once you've left, we will take a short recess. Yep. All right, before we recess, let me congratulate you both.
Thank you.
So you went through a gauntlet. I think you have run probably the hardest gauntlet there is in mock trial, and the two of you are the last two standing, and I can see why. I don't get a vote in this final outcome. I was just presiding, so I'll just take this moment to tell you both how excellent I think you both are. In the meantime, while they are deliberating and before we get the result, we will stand in recess. So thank you both.
Thank you.
knowing full well y'all want to get to the results, I do want to give a chance to our jury to both introduce themselves, so you know who it was that was evaluating today, and also give you brief comments regarding the round. So I will hand it over to our jury. Whoever would like to start? Ben, I'm going to let you start. Sure. So.
Yeah, guys, great job. My name is Ben Yelverton. I'm a trial lawyer here in Waco, and I've coached mock trial teams for about 10 years. You're tremendous advocates. You're already way, way ahead of most lawyers who are going to come out of law school, so feel good about that. To be brief, I'll start with Mr. Sizemore on the defense. I think themes should not only encapsulate your case, but they should also make an argument about what the evidence means, right? So yours was like horror, shock, and fear, or something like that. I think horror, shock, and fear is not a voluntary act, right? Or that doesn't equal a crime, okay? You got to argue about it. And the other thing I'd say is there was this whole exchange where your witness kind of got caught on something at the end of your case in chief. I wouldn't end on that. I would get up and give her a chance to explain her last answer. On the state side, Mr. Jones, tremendous. Just your control over the evidence and the rules of evidence is impeccable. I will say something harsh to you as someone who has struggled with it my whole career. You have a tendency to do certain things like drop off the volume at the end of your sentences when you're responding to the judge, or switch between emotions pretty quickly when you're arguing, or talk to the jury like you're preaching at them. And all those things are unlikable. So I would encourage you to think about trial as a conversation with the jury, and focus on how you're appearing to them. Yep.
Of course, you're going to hear a great job from all of us. Great job. I'm Britta Stanton. I'm a trial lawyer in Dallas. I took a couple years away from first chair work to do some trial consulting and just focus on what lawyers actually do in the courtroom and help them do presentation. You guys did a great job with limited tools. So that was fantastic. And I'm not going to give you substantive comments because hopefully you'll never try this case again, and you both did a fantastic job. I will tell you this. I would happily co-counsel a case with either one of you at any time.
Hi there, my name is Marilyn Brown. I practice in Austin, Texas. I've been practicing trial law there for almost 20 years somehow. And I echo everyone else's comments. I would be happy to have either of you, any of you at my trial counsel table. You all did an excellent job. Mr. Sizemore, I thought you in particular did a good job with the physical evidence and getting your witness off of the stand. That's something that I think people can struggle with, and I thought that was effective. On this side, I thought that you did a good job with arguing the objections and knowing the evidence and the rules. So good job to both of you.
Hi, all. My name is Wesley Lutz. I've been practicing for 20 years. I practice law in Houston and do primarily commercial business litigation cases. So it's fun to hear a criminal case because I don't do that regularly in my practice. But both of you are excellent advocates. The positive I'll give to both of you is that both of you have a unique style, very different in your style. Mr. Sizemore, you're really easy to listen to. You come across as very authentic, as someone who kind of gets right to the point and gets to the punchline. And I thought you did a very effective job on just short burst questions to kind of get where you wanted to. And Mr. Jones, particularly on your direct exam, I thought you did a very nice job of signposting, the issue that you wanted to talk to the witness about and kind of looping in their answer with your next question. A lot of really good who, what, where, whys that you want to let the witness be the star, but kind of, give them a tee-up question. I'm going to give you all one kind of joint piece of constructive advice, not related to this problem, but I think you can use, and it relates to if you're inoculating against a bad fact that you have in the case. Both y'all did a good job of doing that on your direct exam of a witness who had a problem, but I think you both did it a little bit too early because like question number 3 or question number 2 was like, are you a convicted felon? Are you a serial killer? Why should I listen to anything else that you have to tell me? And so I would suggest inoculating is good, but move that more to the middle of the examination where it's less likely to be remembered by the jury, and do something to show that the witness is credible before you undermine their credibility. So if your third question out of the box is you're a liar, you're a scumbag, you're a cheater, then the jury may discount everything they hear in the rest of the exam. You've got to do something to introduce that witness, humanize them, have them tell something that's corroborated before you're then like, okay, and I want to talk to you about one other thing. And then you get the bad fact out rather than stacking that at the very beginning of the examination. So think about how you can deploy that, the timing of doing that, and when you do that in the exam can sometimes matter.
Hello, I'm Letty Martinez. I've been practicing criminal law in Fort Worth 30 years. prosecution for 20 and defense for 10 years. So it was great to be able to watch a criminal trial in action, and again, impressed by the fact that you both could pick this case up and prepare it in such a limited time, when most cases you're going to have months and even years to be working on a case depending on where you are. So very impressive that both of you could do that. And in terms of constructive, I would say Mr. Sizemore have a manner that it kind of, for me anyway, I wanted to be on your side, because you just have this manner about you that, hey, a guy out here trying to fight for my client. And you can't buy that, that just comes naturally. And so you're going to have that forever. And that is a wonderful that you already have that. Mr. Jones, your technical mastering, very impressive where you are. Just, you knew exactly how to respond to the legal arguments. And what I really liked about what you did is you were obviously listening to the witness and adapting from there, which again, that's difficult to do, especially in this. You want to be able to just plan everything out, and you can't. Trial work is adapting all the time. And you did a really great job of that. Overall, I would say on both sides, sometimes it's hard to forget about the big picture, because you get in, what did this witness say? What about this piece of evidence? And one of the things that I was thinking about picture-wise is, and I think it kind of goes into what you were saying, is when you, in this case, you have a situation where, okay, there's going to be evidence going both ways. But the big picture that I was thinking about, that I don't know that either side pointed out, is you have a conspirator who is actually the one that was doing the crime in and of itself and was only going to get a misdemeanor. And then you had the other who, the question is, did she participate or not? Was she in on it or not? She was going to be facing a felony. And so that was kind of overriding in my head, and that never really got pointed out. But that's all I have.
Okay.
I'm going to torture you for like 2 more minutes, and then I'm going to tell you who won. I wanted to, first of all, real quick, I wanted to thank one last time our partners from NGM and the law firm. There are a couple of y'all in the back of the room. Yeah, absolutely. For underwriting the tournament and the $10,000 prize that will shortly go to one of these advocates. And so it's been a great partnership and been great this year as well. I also wanted to thank some of our students, Vivian Noyd, Gaines Jones, Varun Reddy, and Gianna Canales, who've been here all weekend. I'm sure y'all have seen them running around like crazy people, who have been awesome and made this thing function. Kathy Sayre, who's not in the room with us, and Greg White, who helped me write the problem this year. So I thank those people very, very much. And with that, I'm going to bring up Dean Pat Wilson to say a couple of words, and then we're going to get to the announcement.
Well, Robert said that since we didn't really use all the time for the trial, that I could just have all that time. No, I'm not going to talk long. I'm just going to say great job. I agree with everything that has been said. I want to thank all the folks that are here that have participated. It's good to see you, Judge Curitan. And I also want to thank Robert Little, who put on a great competition. So in just a moment, the announcement will be made, and one of you will be very, very happy, and one of you will be disappointed, but I hope that you go away knowing that you all are wonderful advocates, that you're going to do great, and you made it this far, which is really quite an accomplishment. And to any other competitors that are here, great job, because again, I think it's incredible and a little bit crazy that you get a case and 24 hours later you're trying it. So there's much to be proud of. So thank you all for being here. Thanks to everybody, and I will stop talking.
All right.
I'm going to hand it over to Judge Curitan. I do want to say this. We do have a trophy in the building. It is upstairs. Kathy Sayre has it. She is currently, if you're wondering for a working law school, she is currently in a moot court practice because we did not anticipate the round would happen that quickly. So we are going to bring it down. So just be aware of that. And with that, Judge, I'm handing over to you.
All right. So as I may have told you at the beginning, I'm a sitting United States Magistrate Judge in Fort Worth, product of Baylor Law School. I'm very proud of this competition. and you have both honored it with what you did today and all week. There's always one winner and one not winner, and the winner of the competition is Peter Jones from UCLA Lowell. Congratulations, Mr. Jones. Congratulations, Mr. Sizemore. A great accomplishment on both of your parts. And with that, court is adjourned.